The topic that probably generates the most conflict in any divorce or child custody dispute is the visitation schedule. So I want to discuss what Texas law says about visitation, what you can likely expect if you're going through a divorce or you're experiencing a child custody dispute regarding what the visitation arrangement is going to be. First, it's important to emphasize that you and your spouse, you and the mother, you and the father, can always agree on a schedule that works best for you, that reflects the best interest of your child, that is most compatible with your life, and that is most compatible with your schedule. And provided that agreement is in the best interest of the child, the court is going to approve whatever the parents agree on. It has to be in writing. It's going to have to be submitted to the court. But I've never seen a judge not adopt an agreed order with respect to visitation. But what happens if you can't agree? If you're in a contentious custody battle with your soon-to-be ex and you all can't agree on what the visitation schedule for the children is going to be, what does the law say? What guidelines inform the court's determination as to what is in the child's best interest? Because what's in the child's best interest is always the court's driving consideration in determining what the visitation schedule should be. Now, in Texas, we have what's called a standard possession order. And I want to underscore the word standard because a lot of clients ignore it. They pretend it doesn't exist, but it's standard for a reason. And it's standard because that is what the legislature has determined is a schedule that is in the child's best interest. And under the law, there is a presumption that the standard possession schedule is in the child's best interest for children that are at least 3 years of age. Now, what does the standard possession schedule look like? Well, if you're the non-primary parent and you are awarded the standard possession schedule, you will have possession of your child on the first, third, and fifth weekend of every month, beginning when the child is released from school on Friday, or 3 p.m. if the child is not in school, until the following Monday morning when school resumes, or at 8 a.m. if the child is not in school. That's year-round. In addition, during the school year, you get every Thursday from when the child is released from school on Thursday until the following Friday morning when school resumes, or 8 a.m. if the child is not in school. So another way to look at the standard possession schedule is every first, third, and fifth weekend or week of the month, you are going to have possession of the child from Thursday all the way to the following Monday. It's not a 50-50 schedule, but it's not that far off. Notwithstanding that fact, people still fight bitterly over that schedule. So a related question is, well, what about 50-50? Isn't a 50-50 schedule fair? What do I have to do to get a 50-50 schedule? All I can tell you is the best way to get a 50-50 schedule is if you and your spouse or the mother of the child can agree on that schedule. You should not assume that a judge is going to award you a 50-50 schedule simply because you're a great mom or you're a great dad or you think you deserve that schedule because it's fair. In general, most judges are going to order the standard possession schedule for children that are at least 3 years of age. Now, for older children, for teenage children, particularly children who have cars, they're going to ultimately go where they want to go. They're going to spend time with the parent they want to spend time with. So I think it's more common in those circumstances for a court to order a 50-50 schedule. If you have actually been a co-equal parent, you can demonstrate to the court that you share equally in the child's day-to-day caregiving. You prepare half, if not more, of the meals. You take the child to school. You can show that you're the one who takes the child to at least half, if not most, of the child's dental and doctor appointments. You're involved in extracurricular activities. It's truly a shared partnership between you and your spouse. Then you can ask the court for 50-50. My general rule of thumb is don't ask for 50-50 unless you've got at least a plausible case for getting primary. I'm seeing now, particularly in the wake of the pandemic with more people working from home, identifying which parent is the child's primary caregiver is becoming more challenging because you've got, in many instances, many households, two parents who are at home during the day and increasingly sharing equally in the child's caregiving. And that's really, if your question is, well, how do I get primary? the key consideration there is, well, which parent is the primary caregiver? Which parent prepares the meals? Which parent takes the child to school? Which parent organizes the parties and schedules the play dates? Obviously, which parent spends more time with the child during the day? In the absence of any sort of misconduct by either parent, that is going to ultimately drive who's going to be primary. Now, are courts biased in favor of moms in evaluating these things? I would say, frankly, yes, there probably is some bias in the system, but the law is blind to gender. The law makes no distinction between moms and dads in terms of who is going to be the primary parent or who's going to get the standard possession schedule. And that's why it's so critically important that you have a good lawyer on your side who can present all the factual nuances of your situation, of your family life to the court, so that if you have a good case, if you have compelling facts in your favor, that evidence is going to put forward and give you the best chance that you have to either get primary or more time with your child. But again, in the absence of agreement, if you go in front of a judge, you have a contested hearing, it's more likely than not that somebody is going to get the standard possession schedule as opposed to a 50-50 arrangement. Now, finally, I want to address what is the schedule for kids under 3. As I mentioned earlier, standard possession is presumed to be best for kids who are at least 3 years of age. Family code doesn't prescribe any specific schedule for children who are under 3. So generally what happens is we have a schedule that builds up to the standard possession schedule, age 3. It may start for infants, for really young children, with more frequent visits during the week, 2 to 3 times a week, but of shorter duration, maybe 3 hours, 2 hours, no overnights initially. And then after 4 or 5 months, you graduate to a little more time. And then you get to 1 overnight per week. And then ultimately, it culminates in that standard possession schedule at age 3. But again, even in that situation, if you and the other party can agree on a schedule that works for you, then the court is likely to ratify it.